Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
What happens if a lawyer fabricates a court order? Sometime in 2006, Jody Andren sought the help of attorney Ariel Maglalang to secure the annulment of her marriage to Ruby Madrinian. She paid a total of 100,000 pesos to the lawyer. In exchange, the lawyer promised to secure a favorable judgment within 3 months without court appearance. But instead of filing a case in court, attorney Maglalang produced a forged court order to make it appear that the client's husband has been declared presumed dead by a judge. In 2008, the judge involved, Judge Ray Alan T. Drilon of Branch 41, Regional Trial Court of Bacolod City, learned about the existence of the forged order. After seeking the help of the National Bureau of Investigation, Judge Drilon filed a complaint before the Integrated Bar of the Philippines. What violations did Attorney Maglalang commit under the Code of Professional Responsibility and Accountability for forging a court order in a non-existent case? Is disbarment an automatic and appropriate penalty for lawyers who falsify documents? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 11th of July 2025, and today we talk about what violations of the Code of Professional Responsibility and Accountability were committed by a lawyer who forged a court order within the context of Judge Ray Alan T. Drilon and Attorney Corazon P. Romero versus Attorney Ariel D. Maglalang, AC number 8471. It's a per curiam decision of the Supreme Court En Banc, promulgated in August 22, 2023. And joining us to talk about this case is Sandiganbayan Associate Justice Maria Theresa Dolores C. Gomez-Estoesta, a member of the Ethics and Judicial Conduct Department of the Philippine Judicial Academy. Justice Estoesta, Justice Tay, welcome to the Supreme Court Podcast, and thank you for inviting us here at the Sandiganbayan.
Yes, thank you, Attorney Mike. Always a pleasure to work with you.
All right, Justice Tay, for the benefit of our listeners who may not be aware and are curious about the cases filed before the Supreme Court, what is an administrative case and how is it different from an administrative matter or a general register or GR case?
Okay. An administrative case is a disciplinary proceeding instituted against a lawyer, and that includes a judge. We often hear this, but it's said to be sui generis in character, meaning it is not civil or a criminal action. It does not involve a trial, but rather it is an investigation conducted by the Supreme Court into the conduct of one of its officers. So there's a primary goal, and the goal is to assess a lawyer's fitness to remain a member of the legal profession as it aims to uphold the integrity and ethical standards of the legal profession. So an administrative case is thus docketed as AC, administrative case, and it usually refers to a case where the respondent is a private practitioner or a government lawyer. It's different from an administrative matter or AM at this instance when the case docketed refers to a judge as a respondent, in which case it is either AMRTJ for a second-level court judge or AMMTJ for a first-level court judge. It will also refer to an administrative investigation docketed likewise as an AM initiated against a lawyer by the Supreme Court on its own accord, let's say arising from a newspaper or media reports. Now, GR or General Register, we look at the Supreme Court's internal rules. It refers to an initiatory pleading properly filed which is assigned a docket number or a GR number. It identifies the case for record purposes until its termination.
Mm-hmm. So GR number usually are the more common cases that we see.
The
right?
run-of-the-mill cases of the Supreme Court.
Cases.
Yes.
And in fact, there's now an EGR, which is for the electronic filing with the Supreme Court. But for the purpose of our discussion today, Justice Day, who conducts investigations against lawyers and judges when they are charged administratively?
It's actually good, Attorney Mike, that your question differentiated the investigations against lawyers and judges, because I will even stretch the differentiation to government lawyers. Yes, there's a difference. So for lawyers, a verified complaint filed with the Supreme Court may be referred to the IBP for investigation, report, and recommendation, except when filed directly by the IBP, in which case the verified complaint may be referred to the Office of the Bar Confidant or such fact-finding body as may be designated. For judges, the complaints are filed, as we know it, with the Judicial Integrity Board under Rule 140 as amended. For judges, the complaints are filed with the Judicial Integrity Board under Rule 140 as amended. The Judicial Integrity Board may also delegate the conduct of disciplinary investigations and hearings of administrative cases involving less serious charges and light charges against court officials and employees. As a matter of fact, for third-level courts, we have the Committee on Ethics and Special Concerns for the Court of Appeals. We have the Committee on Ethics for the Sandiganbayan. We have the Committee of the Court of Tax Appeals on Employees' Rules of Discipline for the Court of Tax Appeals. Then for the second and third level courts, it can be delegated to the Office of the Court Administrator. Also for the Sharia High Court and Sharia District and Circuit Courts.
And just to clarify, Justice Tay, you mentioned that complaints can be filed with the Integrated Bar of the Philippines. I guess this is for complaints against lawyers.
Yes.
But can they also file directly to the Office of the Bar Confidant?
Yes, they can do that. Actually, for Supreme Court through the Office of the Bar Confidant and then the Integrated Bar of the Philippines, that's expressly provided actually in Section 2, Canon 6 of CPRA.
And what happens after that? If it goes to the Office of the Bar Confidant, the Supreme Court can still refer it to the IBP for investigation.
Yes, that is correct. Especially for lawyers, private practitioners, or government lawyers. But for judges, it's very specific under Rule 140 as amended that they are always referred to the Judicial Integrity Board. Attorney Mike, actually, if I revert back, I mentioned government lawyers because if the complaint alleges acts or omissions in relation to their duties, the complaint can be lodged not just with the Supreme Court if we follow the case of Guevara Castile versus Trinidad, but likewise if we follow Executive Order 292 or the Administrative Code of 1987, it can be conducted by the head of the agency or the Civil Service Commission itself or the Ombudsman under RA 6770. So ang daming processes, no?
Right.
Yung iba naguguluhan, that's why I always tell the participants, especially in MCLE seminar, to differentiate. Is it a private practitioner?
Right.
Is it a government lawyer? Or is it a justice or judge or a member of the judiciary?
Does the rule on forum shopping apply though in this case? Because you have several options. So when you file a case or a complaint before one forum, are you prohibited from filing in another
None,
forum?
because it's always independent from civil criminal cases, and administrative cases are usually have different allegations. So for the Office of the Ombudsman to take over the administrative case, the allegations have to refer to the discharge of the official functions of the respondent. Yes.
Interesting. So if you're a government lawyer, you have
Yes.
you risk
A
facing
lot.
a lot of cases in
That's
different
correct.
forums. Interesting.
That's correct.
All right. But in this case, we know that there's a lawyer here
Yes.
who claimed that he can secure a ruling for annulment
Yes.
before a court. And this is Attorney Maglalang. Specifically, what did he do? And what were the circumstances that led to it? That's why he faced this case before the Supreme Court.
It's very interesting actually, and it's not the first time that a lawyer did this. Attorney Maglalang brought in for his client a forged order or a falsified decision that did more damage to the client considering the legal repercussions and consequential impact it created. His client merely wanted to file an annulment case against the estranged husband to allow her to remarry, as is always the case, is it not? But Attorney Maglalang took in her case and for a fee of 100,000 pesos, assured her that he could get a court decision in 3 months' time with no need of a court appearance. I will specify that because that is the anomaly in itself, is it not, Attorney Mike? Because who gets a decision without a court proceeding?
Exactly.
That's
And
right.
is the 3-month period reasonable?
No, because usually the regional trial court, which has jurisdiction to hear annulment cases, will have 90 days within which to render a decision. So 3 months is really excludes the trial process itself.
Right. So
Yes.
anyone listening to this, if a
Yes.
lawyer promises you
That's correct.
a decision without
Yes.
appearance in court in 3 months, that's a
Yes.
red flag.
That's a red flag. That's correct, Attorney Mike. Yes. So it's in that promise of an expedited process that triggered the administrative case. Attorney Maglalang actually said that the client can meet up with the judge, and since this did not materialize under the pretext that the judge was really busy, Attorney Maglalang said that he knows somebody from the National Statistics Office, which is now the Philippine Statistics Authority who could effect a correction in the marriage certificate. So it was at this instance that Attorney Maglalang handed a forged order personally to the house of the client, which was witnessed by the caretaker. And that started everything because when the client remarried and asked the caretaker to get a certification from the PSA, or formerly the NSO, of the updated record of her marriage certificate, it did not reflect the annulment case. So that started it. The investigation started
and interesting that Attorney Maglalang was even present
Yes,
in the second marriage.
That's correct. He stood as a witness to the marriage. So there was no problem with this identification and participation.
And one interesting aspect of this case is that the woman here was married to a foreigner, at least for the
Yes.
second marriage. And
Yes.
she was about to get a visa.
Yes.
But she could not because
could not.
apparently the records still indicate that she
Yes.
was married to another person.
Another person with fake documents.
With fake documents.
Yes.
So, and what is also interesting in this case, Justice Day, is that the judge himself found out
Yes.
and communicated with the NBI,
That's
had it,
right.
had it investigated, and so they brought this case before the Integrated Bar of the Philippines. Now, how did the IBP Commission on Bar Discipline conclude that Attorney Maglalang resorted to taking shortcuts by
Yes.
using a non-existent order and furnishing his client with a forged order?
It was evident from the records themselves, Attorney Mike, because there were definitive discrepancies. For one, the IBP Committee on Bar Discipline considered, one, the incorrect case number because it did not follow the chronological sequencing of the case records. Very particular kasi ang mga court sa docket number. And then next, there was a name and signature mismatch. There was an interchange of the first two names of the judge. And then, obviously, it did not reflect his genuine signature. And third, the tenor of the decision had a different format, style, and heading. So that was really the red flag in itself. And fourth, it was a non-existent decision because the complainant here presented two certifications from the Office of the Clerk of Court and the clerk in charge of the branch itself that no such case was filed in their record.
It's interesting that the one who forged the document got the name of the judge wrong.
Yes.
Because it's supposed to be Judge Ray
Ray
Alan T.
Alan.
Drilon.
That's right.
But it came out as presiding Judge Alan Ray Drilon.
That is
So
correct.
maybe he should have done further research.
Yes.
All right. Justice, the Supreme Court agreed with the findings of both the IBP Commission on Bar Discipline and the recommended penalty of the IBP Board of Governors. Why did the Supreme Court say there was substantial evidence that Attorney Maglalang authored and used the forged order?
First, Attorney Mike, allow me to define what substantial evidence is for our listeners. So we say there is substantial evidence when there is that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. So following this parameter, there are three factors considered by the Supreme Court. One, there were personal accounts from the client herself and her witness or the caretaker who both identified Attorney Maglalang as the source of the forged order. And this was the terrible thing for Attorney Maglalang because the Supreme Court applied the legal presumption on forgery. Remember the principle, he who has possession of a forged document and used it is presumed to be the author thereof. Attorney Maglalang offered no definite explanation on this. Actually, it was just a mere denial. Second, the Supreme Court reiterated the non-existent case record gauged from the two certifications of the Regional Trial Court. And third, the judge himself, under whose name the forged order was purportedly issued, disclaimed any involvement in the preparation thereof and noted the definitive discrepancies as we've mentioned earlier.
So with what Attorney Maglalang did, which provisions on ethical conduct of lawyers did he violate in authoring and issuing that forged order?
Yes, the Supreme Court was very specific in referring to the Code of Professional Responsibility and Accountability, particularly Canon 2 on propriety, Section 1, proper conduct, and Section 2, dignified conduct. In summary, proper conduct is where a lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. Dignified conduct, a lawyer shall respect the law, the courts, tribunals, and other government agencies, their officials, employees, and processes, and act with courtesy, civility, fairness, and candor towards fellow members of the bar. Ito kasi fake order. So it's really a disrespect of the law and procedural rules. And then the Supreme Court likewise quoted Section 8 under Canon 2 on propriety, prohibition against misleading the court, tribunal, or other government agency. This forged order will certainly be disseminated, is it not? Particularly to the local civil registrar,
Right.
to the Philippine Statistics Authority. So imagine if there's a forged order within the pipeline of our records on status, that really has a consequential impact.
Right.
Likewise, Canon 3 on fidelity, where the responsible and accountable lawyer, a lawyer upholding the Constitution, obeying the laws of the land, promoting respect for laws and legal processes, safeguarding human rights at all times, and advance the honor and integrity of the legal profession. Attorney Mike, with the forged orders, no dignity and integrity at this instance,
Right.
at the outset. From
And
the
you
get-go.
risk
Yes.
you risk ruining the integrity of the entire
Yes.
judicial system.
Yes.
Right. And you mentioned, interesting that you mentioned the Code of Professional Responsibility and Accountability, or CPRA. And I understand that you were directly involved in
Yes.
drafting the CPRA. So you would have personal knowledge and you would be an authority on this. As a member of the Supreme Court Subcommittee for the Revision of the Code of Professional Responsibility. So for those unfamiliar, what is CPRA?
Yes, thank you for that question, Attorney Mike. Now, the rollout has been since 2 years ago and there are still ongoing seminars for it.
Yes.
So in short, sa mga tagapakinig po natin, CPRA serves as the code of conduct for all lawyers, following a values-based framework divided into canons on independence, propriety, fidelity, competence, diligence, equality, and accountability. Justice Ami Javier, our chairperson, calls it the Book of Life to govern lawyers with ethics and lawyers of conscience. So, actually meron ng Code of Ethics, matagal na. Pero ang CPRA, in-update niya yung 1988, yung 34-year-old na Code of Professional Responsibility. So, the CPRA took effect last May 2023 and it has since been adopted by the Supreme Court in its cases.
And what's interesting about CPRA is that you added a whole chapter on accountability.
Yes.
So now there are specific penalties for specific acts.
That's right.
Which was not present in the previous code.
That's correct. Or they've expanded it. They made it clearer. There are now serious offenses. We would know as a lawyer, let's say you're a respondent in an administrative case, you would know which charges are serious, less serious, or light offenses. And you would know if there are mitigating or aggravating circumstances because the CPRA provisions would likewise tell you how to compute the same. It's
Right.
really an interesting read.
So in a way, if you're the lawyer, you're at least apprised of the gravity of
Yes,
what you did.
that's correct.
Unlike before, when you can just say this is a violation of this canon, but you don't really
You
know
don't
what the
know.
penalty is.
That's
so you
correct.
can't gauge how serious that action is.
That's correct, Attorney
Right.
Mike.
And interesting also, Justice Day, is that the events in this case actually took place in 2006.
Yes.
And as you mentioned, the CPRA took effect on May 2023. So why did the Supreme Court apply the provisions on CPRA in this case?
Because the CPRA itself specifically provides that it shall be applied to all cases filed after its effectivity and also retroactively to all pending cases, except, of course, there's always an exception, to the extent that in the opinion of the court, its application would not be feasible or would work injustice, in which case the procedure under which the cases were filed will govern. The exception did not apply in the case of Attorney Maglalang. That is why there was a retroactive application.
And there's also this reminder by the court that
Yes.
if you're a lawyer, regardless of the code that's governing your
Yes.
conduct, you're always expected to uphold the ideals
Yes, that's right.
of being a lawyer.
Being a lawyer.
Right. So that's a reminder to our fellow lawyers. Now, the Supreme Court upheld the recommendation of the IBP Board of Governors to impose the maximum penalty of disbarment against Attorney Maglalang instead of the 1-year suspension originally recommended by the IBP Commission on Bar Discipline. So what was the court's basis for this?
Yes. Falsification of documents such as court decisions or orders is considered a serious offense under the CPRA. It is considered a reprehensible act that affects the moral turpitude of a lawyer. So the penalty of 1-year suspension was considered too light a penalty for, quote-unquote, I'm quoting the decision itself, deplorable conduct of deceitful behavior in falsifying papers in the judiciary. So if a lawyer's conduct falls short of the exacting standards, it blemishes not only his integrity but that of the entire bar, the entire legal system. So why just impose a 1-year suspension when under those circumstances, falsifying a court document should merit the supreme penalty of disbarment?
Can we say, Justice Day, that based on this decision, other rulings by the Supreme Court, that if a lawyer falsifies a document,
Yes.
then disbarment is the automatic and appropriate penalty?
Yes, that's a good question, Attorney Mike. Actually, if you look at the penalties that are imposable in the CPRA itself, Disbarment for a serious offense is not automatic, but it is often considered the appropriate and most severe penalty for lawyers who falsify documents, especially when the falsification is intentional, malicious, and involves the integrity of court proceedings. Serious offense kasi siya. So merong range. So if you look at section 37B, tatlo yung penalty imposable. A is disbarment, B is suspension from the practice of law for a period exceeding 6 months, C is revocation of notarial commission and disqualification as a notary public for not less than 2 years kung notary public siya, or a fine exceeding 100,000 pesos. So because of the range, a lot of Supreme Court cases would say if what is involved is a forged document, then it's the supreme penalty of disbarment. So it's not automatic.
Right.
Nasa discretion pa rin ng Supreme Court.
Still within the discretion of the
Yes.
court. Right. And finally, just to close our discussion, Justice Tay, what should be the key takeaway for both lawyers and litigants from this case?
Yes. There are no shortcuts to legal proceedings. Fabrication of a court order decision is never a means to achieve a target goal. As lawyers, we respect the rule of law, we uphold legal processes, we assist in the administration of justice, we advance or defend a client's cause. I'm just following it from fidelity. But if a lawyer goes wayward by using forged documents, it becomes self-defeating. So the fallout becomes serious and the consequences are real, not just for the lawyer who may be disbarred, but for the entire justice system. So why do it? Is it not in the
Right.
first place? Just go through the process, represent your client in the way, to the best of your ability, and follow the rule of law and the code of conduct.
And especially if the client is paying for your service,
Yes, that's
paying for
right.
what you're supposed to do. Right?
Correct.
All right.
Yes.
So very well said, Justice Tay. Thank you very much for joining us today.
Maraming salamat, Attorney. I've really enjoyed it. Thank you.
And to our listeners, if you wish to read the full text of the decision of the Supreme Court, please visit the Supreme Court website, sc.judiciary.gov.ph, and search for AC number 8471, Judge Ray Alan T. Drilon and Attorney Corazon P. Romero versus Attorney Ariel D. Maglalang. Here's Tiffany Nido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court has ruled that a doctor who offers proper medical advice, clearly explains the risks of a procedure, and secures proper consent from the patient is not liable for medical malpractice. In a decision written by then Associate Justice Mario Lopez, the SC Second Division upheld the dismissal of a complaint against Dr. Abenilo Aventura, head of the Philippine Heart Surgery Department, for the death of his patient, Quintinque. Ruling that Dr. Aventura was not negligent and did not commit medical malpractice, the SC explained that medical malpractice occurs when a doctor fails to deliver the standard of care expected from other doctors in similar circumstances, resulting in harm to the patient. A basis for malpractice is the lack of informed consent, which occurs when a patient agrees to a procedure without being fully informed about its risks and potential outcomes. The SC found that Dr. Aventura clearly informed the patient and his family about the risks associated with the stenting procedure, including the risk of death. He also clarified that another doctor would perform the procedure, and the patient signed the consent forms. In another decision, the SC has recognized that a sudden outburst of uncontrolled emotions, triggered by years of abuse from the accused's father, qualifies as passion or obfuscation, a mitigating circumstance that can reduce the penalty for parricide. The SC's First Division, through Associate Justice Ramon Paul Hernando, upheld the conviction of accused Leopoldo Singcol for killing his father, but lowered the penalty due to the presence of this mitigating factor. While the SC held that self-defense was not applicable in this case, it ruled that passion or obfuscation should be considered as a mitigating factor or circumstance that lessens the penalty. Singcol was sentenced to reclusion perpetua, or a maximum of 40 years in prison, for each crime of parricide and the murder of his sister-in-law. The SC considered the parricide a result of a sudden surge of the accused's bottled-up feelings caused by paternal neglect since childhood, as shown by Singcol's narration and his extreme irrational acts of self-harm immediately after the killing. In another case, the SC has acquitted 2 individuals accused of illegal gambling due to the arresting officer's failure to provide specific details of the gambling activity. In a Panencia by Associate Justice Ami Lazaro Javier, the SC Second Division overturned the conviction of Robert Plan and Mark Oliver Enolva. They were earlier found guilty of violating Presidential Decree No. 1602, which imposes a stiffer penalty on illegal gambling. The SC found that the police failed to prove that the accused were actually placing bets. While the officers claimed to have seen pot money on the floor, they could not confirm the denomination of the bills. The SC stressed that for a gambling conviction to hold, the arresting officer must present clear and specific details of the gambling operations. The SC has also ruled that the 15-year time limit or prescriptive period for filing a bigamy case begins only when the bigamous marriage is actually discovered, not when it is registered with the government. In a Panencia by Associate Justice Samuel Garlan, the SC's Third Division found Erwin Bonbon guilty of bigamy after marrying Elizabeth Bonbon in 1999 while still legally married to another woman. Sentencing Erwin to up to 8 years and 1 day in prison, the SC explained that under the revised penal code, bigamy is committed when a person who is still legally married enters into another marriage that appears to be valid. Case for bigamy must be filed within 15 years from the time the second marriage is actually discovered, not just registered. The Supreme Court said that since bigamous marriages are often kept secret, using the date of registration as the starting point for the time limit would make prosecution almost impossible. On July 9, the SC, led by the 2025 Bar Examinations Chairperson, Associate Justice Ami Lazaro Javier, held a contract signing ceremony with the University of Santo Tomas or UST for the 2025 Bar Examinations at the En Banc Session Hall. The ceremony sealed the partnership between the court and the UST, which will serve as the national headquarters for the 2025 bar exams to be held on September 7, 10, and 14, 2025. Joining Justice Lazaro Javier were Chief Justice Alexander Esmundo, Clerk of Court En Banc Attorney Marifelo Mibao Cuevas, and Deputy Clerk of Court and Chief Administrative Officer Attorney Maria Karina Matamu Cunanan, while Secretary General Reverend Father Louis Coronel, on behalf of UST Rector Very Reverend Father Richard Ang, and Dr. Emmanuel Batulan served as representatives from the UST. On July 10, His Excellency Dr. Andreas Michael Fafanoshka, German Ambassador to the Philippines, paid a courtesy visit to Chief Justice Alexander Esmundo and SC Associate Justices Ami Lazaro Javier, Jose Mairas Marquez, and Raul Villanueva, held at the SC En Banc Session Hall in Manila. Ambassador Fafanoshka was joined by German Embassy Manila Economic Counselor Dr. David Klebs. During the courtesy call, Chief Justice Esmundo and Ambassador Fafanoshka emphasized that although the Philippines and Germany have different judicial systems, the rule of law must always prevail. Other matters discussed included maritime law, competition law, and the use of technology and artificial intelligence in the judiciary. On Wednesday, Senior Associate Justice Marvic Leonen stressed the importance of re-evaluating existing penal systems to give way to an effective and more humane approach to criminal justice. In his message as keynote speaker at the Restorative Justice Training and Conference for Bureau of Jail Management and Penology Lawyers, held in Quezon City, Saj Leonen stated that in restorative justice, the focus is not on punishment, but on using the law and upholding human dignity and social justice. Among the topics tackled during the training and conference were challenges in the Philippine justice system, restorative justice as a new approach, and emerging restorative justice practices. You are now up to date with the Philippine Supreme Court. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Brian Austria, Don Ryan Balza, Lauren Solanio, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.